Good day, sir. I am Anne Rose Tubat, and this is my final examination in Class CLJ 400, Section 8. First question. Define evidence and explain its scope. Revised Rules on Evidence, Rule 128, Section 1. Evidence defined. Evidence is the means sanctioned by these rules of ascertaining in a judicial proceeding the truth respecting a matter of fact. Revised Rules on Evidence, Rule 128, Section 2. Scope. The rules of evidence shall be the same in all courts and in all trials and hearings except as otherwise provided by law or these rules. What are the three kinds of evidence? Briefly explain each. Revised Rules on Evidence, Rule 130, Section 1. Object as evidence. Object as evidence are those addressed to the sense of the court. When an object is relevant to the fact in issue, it may be exhibited to, examined, or viewed by the court. Revised Rules on Evidence, Rule 130, Section 2, Documentary Evidence. Documents as evidence consist of writings, recordings, photographs, or any material containing letters, words, sounds, numbers, figures, symbols, or their equivalent or other modes of written expression offered as proof of their contents. Revised Rules on Evidence, Rule 130, Section 22, Testimony confined to personal knowledge. Witness can testify only to those facts which he or she knows of his or her personal knowledge, that is, which are derived or her own perception. The next question is distinguish corroborative evidence from cumulative evidence. Corroborative evidence is additional evidence of a different kind and character tending to prove the same point. Meanwhile, cumulative evidence is a additional evidence of the same kind and character tending to prove the same point. So the next question is, what is prima facie evidence? It's evidence which, if unexplained or contradicted, is sufficient to sustain a judgment in favor of the issue it supports. Next question is, what is dying declaration? Section 37, dying declaration. The declaration of a dying person made under the consciousness of an impending death may be received in any case wherein his death is the subject of inquiry as evidence of the cause and surrounding circumstances of such death. So next question, what about statements uttered as part of the res gestae? Section 44, part of the res gestae, statements that made by a person while a startling occurrence is taking place or immediately prior or subsequent thereto. So next question is, what is the order of examination of individual witnesses? Briefly define each. So, Revised Rules on Evidence, Rule 132A, Section 4, order in the examination of an individual witness. The order in which the individual witness may be examined is as follows. A. Direct examination by the proponent. B. Cross-examination by the opponent. C. Redirect examination by the proponent. And D. Recross examination by the opponent. Revised Rules on Evidence, Rule 132A, Section 5, Direct Examination. So, direct examination is the examination in chief of a witness by the party presenting him or her on the facts relevant to the issue. So, next, Revised Rules on Evidence, Rule 132A, Section 6, Cross-examination. This may be cross-examined by the adverse party on any relevant matter with sufficient fullness and freedom to test his or her accuracy and truthfulness and freedom from interest or bias. So, Revised Rules on Evidence, Rule 132A, Section 7, Redirect Examination. Its purpose and extent after the cross-examination of the witness has been concluded, he or she may be re-examined by the party calling him or her to explain or supplement his or her answers given during the cross-examination. Rules on Evidence, Rule 132, Section 8, Recross Examination. Upon the conclusion of the redirect examination, the adverse party may be recross-examine the witness on matters stated in his or her redirect examination. Revised Rules on Evidence, Rule 132A, Section 9, Recalling Witness. After the examination of the witness by both sides has been concluded, the witness cannot be recalled without leave of the court. The court will grant or withhold leave in its discretion as the interest of justice may require. Briefly explain what is a judicial affidavit. The Judicial Affidavit Rule or JAR took effect on January 2013. A normal court proceeding will take around 3 to 5 or even more years to be fully decided. By requiring the submission of written affidavits of witnesses through the JAR, the time for concluding a court proceeding will be shortened. So next question. An offer of compromise in criminal cases is an implied admission of guilt. What are the two exceptions? There are only two exceptions where compromise is not admissible as an implied admission of guilt in criminal cases. One is in quasi-offenses or acts defined and penalized under Article 365 of the Revised Penal Code, reckless imprudence and simple imprudence of negligence. And two, those allowed by law to be compromised. Their usual examples are found in the Revised Penal Code, particularly Article 266D of the Revised Penal Code, the compromise that the victim agreed to marry and indeed got married to the accused in a rape case, or if a compromise was made before the filing of the criminal complaint in order of evidence to be admissible, it must be relevant and competent. So next question, when evidence relevant? When is evidence competent? Relevance under Rule 128, Section 4, evidence is relevant if it has a relation to the fact in the issue as to induce belief in its existence or non-existence. And competence in addition to relevance, admissible evidence must also be competent under Rule 128, Section 3. Evidence is competent if it is not excluded by the law of this rule. If a piece of evidence is disqualified by the law or the rules of court, then it is not competent and will be inadmissible. So, next question is, what is a leading question and when it is allowed? So, Section 10, leading and misleading question. A leading question which suggests to the witness the answer which the examining party desire is a leading question. It is not allowed except A. On cross-examination, B. On preliminary matters, C. When there is difficulty in getting direct and intelligible answer from a witness who is ignorant, a child of tender years, is of feeble mind, or a deaf mute. D. Of an unwilling or hostile witness, or E. Of a witness who is an adverse party of an officer, director, or managing agent of a public or private corporation, association, which is adverse party. So next question is, what is a misleading question? A misleading question is one which assumes as true a fact not yet testified to by the witness or contrary to that which he or she has previously stated. It is not allowed. Distinguish burden of proof from burden of evidence. So revised rules on evidence, Rule 131, Section 1, burden of proof and burden of evidence is the duty of party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by the law. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. So next question, what is the standard of proof necessary in civil cases? Revised Rules on Evidence, Rule 133, Section 1, preponderance of evidence, how determined in civil cases the party having the burden of proof must be established his or her case by a preponderance of evidence in determining where the preponderance of superior weight of evidence on the issue involved lies. The court may consider all the facts and circumstances of the case, the witnesses' manner of testifying, their intelligence, their means and opportunity of knowing the facts to which they are testifying, the nature of the facts to which they testify, the probability or improbability of their testimony, their interest or want of interest, and also their personal credibility so far as the same may legitimately appear upon the trial. The court may also consider the number of witnesses, though the preponderance is not necessary with a greater number. Criminal cases revised rules on evidence, Rule 133, Section 2, proof beyond reasonable doubt. In a criminal case, the accused is entitled to an acquittal unless his or her guilt is shown beyond reasonable doubt. Proof beyond reasonable doubt does not mean such as degree or proof. Excluding polity of error produces absolute certainty, moral certainty only is required, or that degree of proof which produces conviction in an unprejudiced mind. Administrative cases briefly define each. Revised Rules on Evidence, Rule 133, Section 6. The substantial evidence. In cases filed before administrative or quasi-judicial bodies, a fact may be deemed established if it is supported by substantial evidence or that amount of relevant evidence which is reasonable mind might accept as adequate to justify a conclusion. Substantial evidence is the least quantum of proof required by the rules. It is applicable in administrative actions which, unlike judicial actions, do not include conducting full-blown trials and are meant to be concluded with greater speed. An administrative body can render a decision on the basis that the evidence presented is evidence, which a reasonable mind might accept as adequate to justify a conclusion. This means that the evidence can make a reasonable person believe that the allegations have occurred. So, next question, define what are public documents. So, in Revised Rules on Evidence, Rule 132, Section 19, classes of documents. For the purpose of their presentation in evidence, documents are either public or private. A. The written official acts of records of the sovereign authority, official bodies and tribunals, and public officers, whether of the Philippines or of foreign countries. B. Documents acknowledged before a notary public except laws, wills, and testaments. C. Documents that are considered public documents under treaties and conventions which are in force between the Philippines and the country of source. And D. Public records kept in the Philippines of private documents required by the law to be entered therein. So next question, how do you prove and present in court private documents? Revised Rules on Evidence, Rule 132, Section 20, proof of private documents. Before any private documents offered as authentic is received in evidence, its due execution and authenticity must be proved by any of the following means. A. By anyone who saw the document executed or written. B. Evidence of the genuineness of the signature or handwriting of the maker. Or C. By other evidence showing its due execution and authenticity. Any other private document need only be identified as that which is claimed to be. The original document rule states that when presenting a document as evidence, only the original is admissible. What are the four executions? So, Section 3, original document must be produced. Exceptions. When the subject of inquiry is the contents of a document, no evidence shall be admissible other than the original document itself, except in the following cases. A. The original has been lost or destroyed or cannot be produced in court without bad faith of the part of the offerer. B. When the original is in the custody or under the control of the party against whom the evidence is offered and the latter fails to produce it after reasonable notice. C. When the original consists of numerous accounts or other documents which cannot be examined in court without great loss of time, and the fact sought to be established from them is only the general result and of the whole. And D. When the original is a public record in the custody of a public officer or is recorded in a public office. Next question, who can become a witness? Qualification of witnesses, Section 20. Witnesses, their qualification. Except as provided in the next succeeding section, all persons who can perceive and perceiving can make their known perception to others may be witnesses. Is an extrajudicial confession sufficient to sustain a conviction? Section 3, extrajudicial confession not sufficient ground for conviction. An extrajudicial confession made by an accused shall not be sufficient ground for conviction unless corroborated by evidence of corpus delicti. And that's all my answer in final examination. Thank you, sir.